Welcome to the Bill Walton Show, featuring conversations with leaders, entrepreneurs, artists, and thinkers. Fresh perspectives on money, culture, politics, and human flourishing. Interesting people, interesting things.
Welcome to the Bill Walton Show. I'm Bill Walton. I thought it'd entertain us with an opening from a recent page one story in my favorite, New York Times. Here's what they say. The Supreme Court moved relentlessly to the right in its first full term that ended Thursday, was the most conservative since 1931. Well, what's horrible for the New York Times is wonderful news for the vast majority of Americans. And among the most significant rulings, even if it doesn't capture all the headlines, is the ruling about the EPA, West Virginia versus EPA. That ruling not only stops environmental extremism in the EPA, but it also could stop major power grabs by bureaucrats at other agencies that have become like a fourth branch of government. The so-called administrative state has become an enormous and growing threat to every American's constitutional freedoms. Joining me to talk about this are two experts in this with a group I just love, the nonprofit New Civil Liberties Alliance, founded by Phil Hamburger, and they're following the EPA and all the other administrative rulings and legal rulings throughout government. Rejoining John Vecchione, great guy, returning guest, senior litigation counsel, focuses on strategic litigation in the federal district and appellate courts, including the Supreme Court of the United States. And Casey Norman, a recent joint staff member at NCLA who prior to NCLA worked in the private sector as a restructuring and bankruptcy associate at Deckard LLP. And we were joking before the show, I think her restructuring and bankruptcy skills may come in handy when we think about what's going to happen with our federal government, especially its debt. So anyway, with that gratuitous remark, John, welcome. Casey, welcome. John, why don't you kick it off? What about this ruling, and what about your real personal interest in how this has evolved?
You opened up with the New York Times article, right? The New York Times is, it's doom, it's horror, you know.
Whenever they're unhappy, I'm happy.
But almost everything, except for the Second Amendment case, New York Rifle, all they did was say that legislatures should be doing this. For instance, on the case we're going to discuss, they didn't say this couldn't be done. You couldn't regulate greenhouse gases this way. They said that Congress has to say you can, right? So it's not gloom and doom. Just have your representatives do it. And the same on the Dobbs case. They said, look, if you want whatever the legislatures want to do, we the people go and do that. We're not going to be the referees anymore. And on the Second Amendment, they said you can't stop people from exercising their Second Amendment rights, but they went out of their way to say you could do background checks. We haven't said anything about what type of weapons you can have. These were all moderate decisions based on representative government. And I do think, though, there is one thing that's bothering them that I think everyone should be very happy about. I started my legal career, I went to Georgetown, so I was in D.C., and I went to the Bork hearings when Robert Bork was appointed by President Reagan to be on the Supreme Court. Ted Kennedy came to Georgetown, gave a big speech about all the horrible things that were going to happen if Judge Bork got put on the bench. And I was the president of the Federal Society then, and I wasn't a lawyer, but I wanted to go see it. And in those days, you could go to the Supreme Court and watch the Senate. You could go to the Senate and watch the hearings, but you couldn't stay. You got a half hour in your seat, and then you had to go out and go to the back of the line. And I went to the back of the line about 3 or 4 times and watched those hearings in person, and I watched them on TV. And all of the Bork hearing, all that fight was about what we're talking about now. Why do you write down law? If you write down the laws, don't those words mean something? And can they mean anything? And I think the fight here is over whether or not the administrative state, the agencies with experts, are just going to be able to take broad, unspecific language to change the whole society.
So the law they were referring to that Congress sent the EPA had nothing in it about what they'd chosen to do to regulate.
So,
Well, they found penumbras and emanations.
well, no, I think it's section 111, Casey?
211.
211. So there was a section that said that you could use the best systems, right? They're using the best systems, the EPA, in this section of the Clean Air Act. But what the court said was this was a tiny part of the Clean Air Act. It was ancillary to the main focus of the Clean Air Act. So what is the court doing here? I mean, what was EPA trying to do? What EPA was trying to do is, instead of saying this power plant is putting off this many CO2 gases, so you have to put this scrubber on that point source, part of what the Clean Air Act does is say that the states give you a program, and then the EPA kind of approves it and then sets certain levels for those point sources. But what the EPA says is, we are going to set the CO2 levels such that the coal plants can no longer operate. All right? They want to put the coal plants out of business completely. And the court said, well, that's a pretty big decision. You're doing this through Section 211? You can't use a tiny section.
Section 211 of the, what act?
Of the Clean Air Act.
Clean Air Act, okay.
Right.
And so this was all done in the 1970s.
Yeah.
And this is, I was just talking about Bork, the 1970s. Who was the left-wing maniac president who signed all this legislation? Richard Nixon, right? So Nixon signed the EPA, the Clean Air Act.
In many ways,
EPA.
he was as bad as Lyndon Johnson.
Yeah. So, but this was the height of the administrative state, the 70s, on I think both the court and in the Congress, and Kagan points this out. They were making big law, she's saying. They knew what they were doing. They were creating the EPA, and they said, these are the problems, we hand them to you forever, is kind of how they look at it. And so if they can find any little bit of a word that they can then base this program they want, because they want to get rid of coal. And they said, if we want to get rid of natural gas, we can get rid of that too, right?
Right.
I'm not wrong about that.
All renewables.
Yeah, we could switch to all renewables if we want. So this really disturbed the court in this case. And West Virginia versus Environmental Protection Agency is big because they've actually taken from a course of law, a bunch of law that they've been forming over the last 20 years?
About that, yeah.
15, 20 years at least. Although Gorsuch would tell you John Marshall was doing it. And I think there's something to that.
John Marshall, our first Supreme Court justice.
Third,
okay,
greatest.
the biggest one, yeah.
So what they're doing here is saying, look, if an administrative agency wants to do something big that affects huge amounts of people, huge parts of the economy, they can't take a small, they got to base it, they got to show us clearly why that is. It's called the Major Questions Doctrine. And we've been calling it the Major Questions Doctrine for some time, meaning we in the profession and the people who scribble about this stuff in the law reviews, they've been saying, this is the Major Questions Doctrine. But they never used it in a court case before. They never said that.
I'd never heard of the Major Questions Doctrine until the last week or two. What
Casey?
is,
Yeah.
Casey, what's the Major Questions Doctrine? Since this is the big thing that seems to have.
Basically, I mean, and they describe it in this case. I think Gorsuch lays it out pretty clearly. But what it is when you have a question like this, where an executive agency is going to be making decisions and taking on authority that's going to majorly impact the nation in political and economic ways. If there is no clear, explicit authorization from Congress in the text of the statute, they cannot do that. And the court should meet that with skepticism, and this law should not, it should be rendered or deemed unconstitutional.
So the gist of it is that we're going to delegate to the bureaucrats small things. You can do tweaks and things like that, but you can't change it so that you really change the major policy questions, major questions.
And I think not even limiting it to just tweaks, but I think here they're looking at, like, for instance, in this situation, if you allowed the EPA to do what it wants to do here, and basically they're saying these coal-fired plants have to shut down and convert completely into different kinds of factories, whether it's wind farms or solar or fuel, other kinds that are not, not the way they're functioning currently. And this costs billions of
BlackRock
dollars.
thinks Chevron can get out of the oil and gas business and go into wind and solar.
Right.
So that's kind of thing. I mean,
Right.
it's called magical thinking.
Right. Yeah, exactly. So, I mean, they hadn't explicitly, the court in its majority opinions, I think Kagan points it out, they hadn't explicitly called it this, though there are some cases within the last 15, 20 years where it's this same reoccurring issue where an executive agency is just seeing where it's not there in the text of the statute, this immense power, and trying to move forward with it through this implied power that they claim is there.
So just so everybody understands, you can find these decisions and opinions on the Supreme Court website, and there's one main decision, then there's Gorsuch's, what do we call that?
It's a concurring opinion.
Concurring opinion, and then we've got Kagan dissenting, and Kagan, of course, thinks that only Elena Kagan understands how these things should be decided.
And I will confess this. So I think that steel sharpens steel in the law. And that means that you have to have the best against the best to hone the arguments. And the one thing about Kagan, when she was at Harvard, she put a lot of textualists and constitutionalists on the reason Harvard isn't Yale, partly because of her.
Quick, explain textualists and constitutionalists.
Okay. So Kagan says, so a textualist and an originalist, I should say, is that the first thing you have is the words of the statute. You don't look at the intent of the legislature out in the air somewhere. They use certain words, so use those. And if the meaning of words has changed, the originalist part of it is you use, this is the best type, there's huge disputes about this, but the best type of originalism is you use the common sense of the words as understood by normal people at the time. All right, that's the originalist part. So this is very controversial among certain professors because they want the courts to say what the modern sense of the world is, rather than the legislature. And so this textualism and originalism was very controversial. When I was in school, Brennan gave a whole speech against the Attorney General. Ed Meese had given an originalist textualist argument. And they went back and forth in three very, in both law review articles on whether or not this was good or bad. And the originalists and textualists believe it's the only way that democracy can work, because if the people can't fix what they want the law in by having their legislatures write it, and then those words not changing until they come back again, you don't really have, it's a legitimacy question. You don't really have a democracy or representative government. So that's what and Kagan understands these arguments. I'm not sure all of the other left-wing judges on certain of the courts really understand them. She understands them, and I think that's why her arguments, reason Gorsuch writes his concurrence isn't because anything Roberts said he didn't agree with. He said it because I got to get back at Kagan because she's scoring some points here.
So he wrote his after she submitted her dissent?
I believe so. I believe so
okay.
Because they're talking, they cross-talk in them, right?
I think they all read each other.
Yeah, they mention each other. So they're really going at it. And in fact, if I may, I'm just going to put on my glasses for a second because for your listeners and their viewers, really, this fight about who's the real originalist and who's the textualist, Kagan says, I'm the textualist, not you guys, but I want to bring up Gorsuch says, wait a minute, this isn't brand new. This major questions that Casey was telling us about, we didn't use the word, but if you look at FDA versus Brown and Williamson tobacco, well, that was the case where the FDA wanted to eliminate cigarettes, right? And the Supreme Court said, well, you're allowed to do a lot of things, but they didn't give you the right to eliminate tobacco because they would have said that. That's like kind of a big deal. So, but they didn't use the term major questions. And then Gonzalez versus Oregon. Attorney General Gonzalez under Bush wanted to use the ability to license doctors to prescribe drugs to criminalize that when Oregon allowed assisted suicide. So they said, so he set up a rule that if you used your prescriptions for assisted suicide, it would be violating the act that allowed your license. And they said, no way, you can't do that. That's not what that's for. And so again, they would have said that in the drug laws if that's what they meant. And then Utility Air Regulatory Group, the EPA, was another EPA question. They keep going on. Each of these cases, and then our favorites, because NCLA did this, we put in amicus briefs in these two cases. That
New Civil Liberties Alliance.
Yes, we
Okay.
put in amicus briefs, and we're very happy. God knows I did tons of CDC litigation. Alabama.
Well, you're checking that one. Let me just say, this is Bill Walton Show, and I'm here with John Vecchione and Casey Norman, NCLA, and we're wandering deep into the meaning of originalism and textualism and the meaning of words.
No, yeah, and so, but because of the COVID emergency, two big cases have come out of the Supreme Court in the last 2 years. Alabama Association of Realtors v. Department of Health and Human Services and National Federation of Independent Business v. OSHA. And the first one says the CDC knows nothing about whether or not you should have evictions in states or not to stop COVID. That's not their bailiwick, right? They don't know anything about that. They said you can't do that. And they threw out the eviction moratorium. And in the NFIB case versus OSHA, they said, look, you're supposed to regulate health and safety. You can't mandate vaccines to every company in the world.
How does this, we got to talk about
Yeah.
the term Chevron deference, and there's this, I know enough to be dangerous, but wasn't there a ruling that said that when the Congress passes things, there's a sense that the agencies are experts and they know what they're doing, and so we're going to defer to their expertise? And hadn't that been governing a lot of this for a long time? And we think it's bad law, but there it is.
Look,
Is that-
why don't
is
you
that
let
a fair-
Casey
is that-
say what
is that a
Chevron
fair-
deference
Yeah.
You're
is?
making too many faces, John.
Yeah, I
For
think-
people listening,
Go ahead.
Yeah, and I think what gets forgotten or maybe glossed over by the courts a lot is that there are two steps to Chevron, and the first one is looking at the text and seeing if there's ambiguity, and if there is not, and you can tell what the statute is saying, you stop there.
When was Chevron decided?
Do you know? John?
87 or
87,
86.
so-
It's a Scalia opinion.
They
It's a
all are.
Scalia opinion.
All the key cases are. But then if you go beyond that and you say, okay, there's ambiguity here, we're not really sure what the words mean, then you're supposed to defer to the agency's interpretation because presumably they're the experts in whatever it's talking about. So long as it's reasonable and not, absolutely insane and doesn't fit at all with what the text says. But I mean, in practice, you see courts deferring a lot to the agencies, and maybe even when the text isn't ambiguous.
And that, in this case, the D.C. Circuit, this was appealed from the D.C. Circuit.
Yeah.
The D.C. Circuit approved this regulation based on Chevron deference. They said, this Section 211, it kind of gives them something, and it creates an ambiguity, and we think EPA can go ahead and do that. They use Chevron, and the majority doesn't mention Chevron. We were all kind of shocked. I think everyone looking at this was like, are they going to cut back Chevron some more? Chevron deference.
And only Kagan mentioned it.
And Kagan mentions it. She's
Yeah.
the only one. And she says, this isn't the type of thing, this is not a Chevron case. But in any event, and she's the only one who mentions it. And nobody knows, because there's tons of cases where they could have mentioned Chevron this year, which they didn't. So something's going on that's kind of a mystery to all of us.
Let me get way into the theoretical here. You're more recently graduated from, you went to Georgetown as well.
Yeah.
Good law school. But the world's changing, and I'm kind of in a words mean what they mean mode, but with deconstructionism and critical race theory and woke and all these sort of ideas about what things really are, has all that deconstructionism collided with what the law schools are teaching now?
I mean, I think when I was there, it was before the real storm hit. I graduated in 2019.
Yeah.
And I didn't see so much of it. I think the craziest thing we saw was Trump getting elected, and that obviously stirred up a lot of emotion on both sides. But I think I kind of escaped, or maybe I turned a blind eye to it and avoided it.
Yeah.
But it seems as though most recently, within the past couple of years, things have really kind of...
But law schools are even now teaching that people, if you've got an unpopular opinion, they don't need to represent you. So the whole advocacy system, and we're wandering way off the EPA topic.
No, but that's why I
here, but
said steel sharpens steel. I
Right.
was discussing with Kate. I never thought I'd get to the law schools because I thought because you had to represent people, you had to know what the other side was. And one of the exercises we always had, I think when you went there too, you had to take the side you didn't like and argue
all the
it.
time. I mean, that's part of being a lawyer, I think. You have to be able to see perspectives.
that is the way it works.
It has to, but
Yeah.
apparently now, maybe not. And you look at the big law firms in D.C., they just, the fella, Consovoy, who argued and won the national.
Had to resign.
Yeah, because they said, no, we're not going to take those cases anymore. You got to go. And they had approved him having those. It's great. There is a certain lack of professionalism in that for the law, I think. But it is a different topic. For West Virginia versus EPA, I think it's an important case because it is saying we are not going to let you do huge things that would have huge political and economic consequences unless Congress has really done it. And the thing that they do here to show that the New York Times is not correct, they said acid rain, right? They had a cap and trade for acid rain. Congress passed the law and said this acid rain problem is really bad. You, EPA, can do this, that, and the other thing. And Roberts says, look, we approved that. We said that was fine. That was part of the law. You're allowed to do it if you've got the right legislative action, so go do it.
Didn't Congress, though, in this case, try to pass something, Waxman-Markey, that would have given a legislative seal of approval, but it couldn't pass? And then the Democrats had big majorities at the time. So I think the EPA knows this. They're the only people that have had the power to do it.
Right. This is a fight, and so that they also have a fight over this.
Yeah.
So the majority and the dissent have a big fight over this because what do you do when Congress doesn't do anything? Because Congress is not supposed to do anything, right? Under the constitutional system, it's supposed to be slow and it's supposed to be hard to do. So Kagan says, well, wait a minute. You can't use the fact that something failed to say what the law was at the time, which is intellectually true, but there is a big problem, and I think does Gorsuch use the pen and the phone here, or was that another case?
They had pen and the phones in his opinion.
Right, exactly.
In his concurrence.
Right, so he is directly talking about, well, wait a minute, you guys tried to do this, you didn't do it, and then suddenly the agency pops up and says, we found this part of the law. What they're saying is not that completely invalidates it, the failure. What they're saying, it raises judicial suspicion for it.
So what does this mean for the rest of the EPA's agenda? I mean, can you now take this and apply this to other things they're doing and say, well, look at this, this other thing, you shouldn't also be doing that?
I feel like that's a big part of the whole like doom and gloom and all the people saying how radical this was, because I don't know, and I think John touched on this already, that this didn't do that much. It didn't shut down the EPA's ability to function. And they point out
That's too bad.
yeah, maybe just on that, it's a shame. But yeah, they really just said the manner that they went about this, and they had an agency. And actually, going back a little bit, it's kind of useful to know the background on this. Congress had already addressed this issue of carbon dioxide emissions. I think it was during the Obama administration. The House passed legislation that was along these lines, granting authority to do these kinds of extreme things, and the Senate did not. And I think Obama is quoted saying, well, if we're not going to be able to do it in Congress, we're going to do it in the executive. And that's actually, I think, where the CPP or the Clean Power Plan actually came about, because they acknowledged Congress declined to do this.
Well, initially, the EPA did a lot of good. I mean, clean air, clean water, we really have made a lot of progress and all that, but this is just a clear case of mission creep.
And here's what this case does that's important. If you come into with an ambitious legislative, and if you want to transform the country, and you get elected, and you don't have majorities in the House and the Senate, you're not going to be able to implement a vast new program, through the administrative state if West Virginia v. EPA holds up. Because what they said was, you didn't do this for 40 years. For 40 years, you never used it this way. If they had been using it before, if they had showed that this was a continuous course of conduct, I think it would have held up.
Right.
And so what they're saying is you can't do something brand new through the administrative agencies. When you want to do something brand new, go to Congress. And I think I was pointing out that, in point of fact, the Clean Power Act, the Clean Power Regulation, Clean Power Plan here, this regulation, never went into effect, and Kagan complains about that. The Supreme Court said, we're staying this act until it gets up to, this regulation until it gets up to us. Never went into effect. Trump gets in, his administration withdrew it, saying, This is a major question, and it's not in the statute. So the EPA said that at that time under that group,
Right.
under that administration. Then Biden got in, and they didn't reinstall it. They said, we're working on it. It doesn't exist right now. So why are you taking this case? And I think it's Kagan's strongest point, and she's really using it against Roberts, because Roberts is always saying how he's a judicial minimalist, and he always calls balls and strikes. But he took this case even though the regulation had been withdrawn. He didn't wait for the next regulation. So I do think that the question here is, if you have an ambitious plan and there's not a clear basis of it in the law, you got to get Congress to go along.
Well, what about how this affects, the Biden administration's got a whole of government approach to climate. And so you look, for example, what the SEC is doing with their climate disclosure. Does this affect that, and does that make that more challengeable?
I'm going to go out on a limb. I think it definitely does. Do you know today, Texas is going to, I just was reading the paper, DACA, the program that the Immigration Service has,
Okay.
that was implemented under Obama, but stayed in place because of judicial rulings under Trump, which allows illegal, undocumented immigrants in the country to stay in the country because they don't have the resources to throw them all out. But it's like 11 million, and they're not going to do anything about it. They've basically given them a pass, even though the law doesn't give them a pass. Texas is saying that is such a major question that Immigration Naturalization Service can't do it anymore using this case. And you're going to see it for the SEC.
Okay,
What's
so
some
that
of the other
affects, that affects immigration, but this will also hopefully affect what the SEC is trying to do with the climate disclosures?
I would think so, because you have the economic impact that would have if you're thinking about all these different
That's a
companies that are
major
going to be.
question.
Yeah.
This is a real blow to the markets.
That's the biggest one I've actually heard, most likely one to be affected by this case and this kind of the major questions doctrine.
We got so much to cover in such short a time. How does this affect my favorite, the Massachusetts versus EPA, where they decided CO2 was a toxic substance, even though it sort of keeps most of plant life alive?
They didn't say it was toxic. They
Okay,
said
well,
it was a
that's my
pollutant.
word,
Well,
not
no,
theirs.
because it's important, because in this case, they said if it's toxic, EPA can do a lot more. All right?
Right.
This case does say, look, here's what's happened here. The Supreme Court decided CO2 was a quote unquote pollutant, right? Alito hates that. Alito didn't like it then. He doesn't like it now. So he says it's not a pollutant. Could they regulate us all of us right now, because we're exhaling CO2? Are we all point sources? This is his problem.
You say Alito didn't like, you don't like it either.
I
What do we
think that the Congress had to say so. And I think that the theory of the global warming is different from the pollutant idea that I think the Clean Air Act was passed with.
Okay.
It was particles. It was things that could harm you directly. This is sort of a bank shot, but I don't think the Supreme Court's going to go back and change it, because it's been around now for quite a while and Congress hasn't said boo. So, and it's a statutory interpretation. I don't believe that the court's going to change that ruling on the CO2. There's all the judicial canons, I think, say, well, maybe we were wrong, but they could fix it any time.
I think Roberts explicitly says something along those lines. He said if this issue had come up where Congress had said, you coal-powered companies, you're going to decarbonize within this period, and actually said, in the words of some of the text of the statute, said something along those lines. He leaves that open, but he says if it had come along to us that way, instead of just having this very open-ended kind of end of the statute catch-all provision without the actual language in there from Congress. There are two different scenarios, and he kind of implied, that could be a route, but it's the more proper route, at least under constitutional principles.
How do you think Congress is going to respond to this ruling?
I'll tell you November 15th.
Okay. Okay. That's a fair. Does this increase the likelihood of court packing?
Oh, it makes a new constituency for court packing, because the environmental movement.
Court packing means basically
Yeah.
adding four more
Right.
to change the balance of power.
And now there's a new idea where they'd set up a statute that would have term limits of like 18 years, and if the current justices did not abide by the 18 because they don't have to because they got lifetime appointments, they'd appoint new judges. It's like a fallback provision. It's a theory. It's a law professor theory. But it's like in stages. I just think that it's a bad time. I just think politically they're going to have a hard time because what I just said about November, I mean, if they had the power to court pack, they'd have the power to change the EPA rules.
Yeah.
Right? Why not? And I will say this. A carbon tax is an idea that has, people got up in arms about it. They went against it. But Congress has never put in the carbon tax because of the tax problem, right? They don't want to be taxing everybody, especially with high gasoline prices. Right. But if there was political will to pack the court, I think there'd be political will to do whatever they want with the EPA. I mean, why would you pack the court when you could actually change the law the way you want? And all these judges, certainly Roberts and Kavanaugh, say we're not. If Congress passes this, we're upholding it up, right? We're not going to strike it down.
It's a really short-term vision, those who want to do this. And I think there are enough Democrats who see that, like, if we do this and pack the court, what stops the other side from doing the same thing? And it's like this infinite problem that never actually gets resolved, and the court
We'll have a
becomes
court the size of the House of Representatives or something.
Yeah, I mean,
Just
because how does
keep
it stop?
I'll see you 4, I'll raise you 10.
And that's another thing. Well, the other thing is they say, oh, this is all because of there's the Senate and there's disproportion in the Electoral College. Well, they stopped expanding the House in 1912. That was the last time we expanded the House. They could expand the House and all the electoral votes would change and the big states would get more electoral votes, percentage-wise. And they don't. It's a legislative fix. You don't have to amend the Constitution. And they're coming up with all these ways to amend the Constitution. I don't understand it. But to answer your question, yes, it increases the constituency for doing something with the courts because a powerful group, I think you raised Blackstone, right?
Yes. Larry Fink is all in favor.
Right. All the regulated parties put in a brief in support of the EPA in this case. And I think with Blackstone and they're going to want to change this because, I don't know, maybe they got an arbitrage. Somehow they think they can make money from it.
This is the Bill Walton Show. I'm here with John Vecchione and Casey Norman, and we're talking about all the implications of the recent EPA ruling that I guess reined in the EPA. Now, it seems to me this is an agency that needs some reining in. As I understand it, they were about to roll out something where they're going to regulate how much we could heat or cool our houses, and set limits on that in order to cut back on energy use. Is that something that have you heard about that?
I had not. The one I heard was gas generation. All the cities and the EPA are stopping gas stoves and things.
Yeah.
And I think that's insane because I don't know if you've ever cooked on an electric stove. It's not
so great.
Right, exactly. But I do think that because this is a 6-3 majority, because Roberts and Kavanaugh and Barrett and the folks who aren't Clarence Thomas are on board with this, and even Kagan says in her dissent she had to talk about all the time she joined with the majority striking down administrative laws as going too far. Don't forget, she was Obama appointee who struck down part of the Obamacare as going too much against the states, right? So some of these cases they mentioned, Kagan was in the majority. So I think that this has some legs. Certainly Breyer, we don't know how Jackson's going to come out, but Breyer also would sometimes rein in the administrative agencies a little bit when he thought they hadn't gone there, even though he's a big administrative state guy. So I do think that this is going to have legs.
By one count, there are 432 agencies. You're the administrative law person. How many of those agencies have administrative law judges, and how pervasive is this problem?
I don't know how many they have. I mean, I know some of them don't.
So last time I was here, you asked me that.
I did.
So I
I'm in search of.
So I looked it up.
Look, I used to teach accounting, and so I want to get this very precise as to what we're up against.
So I had people look it up, and we found a chart. And I did not bring the chart with me, but it is something like, of those agencies, something like 40. I had thought it was somewhere in the number of 10 or 12, but it's something like 40.
Okay.
It's a large number. But the ALJs, the big ones are Social Security, Medicare, that they have tons of them because they have to make tons of rulings about whether you get your benefits or not all the day. Those are the big ones. The EPA does not, because it brings you to federal court when it sues you. And the SEC obviously does, and the FTC obviously does. I will bring my chart the next time you ask me here, and I will give you the full answer. But it was an interesting question. But the real problem here, I think, for the EPA is that they have big projects. The environmental, we used to call it the conservation movement. We wanted, as you said, I remember going to New York City as a boy, and when I came home, I had to wash my hands and face, and the soot just came off. This is in the early 70s. It was amazing.
We had massive problems.
Massive problems
with air and water.
Yep.
Massive.
And so
the Cleveland River really did catch on fire.
Exactly. There were all, and there were all these externalities, and this was created, and it's done some good. And I'm not saying certainly in the heavy metals area, it's still doing some good.
Yeah.
But this idea that everything's connected to everything else, so that the EPA gets to regulate everything. Bill, if there was an agency, if Congress just wanted to have the do-good agency, and they say, this agency...
Don't give them any ideas.
This agency will do everything good and nothing bad. And we give this agency all the powers to do good that we have here in Congress, okay? And then don't bother us, right?
Here's the ball.
And so then they have the do-good agency. And then the agency says, well, we've got authority over all the problems, and we're doing good here. And then we use Chevron, and, well, there's an ambiguity in the law, and we say we're doing good, so who are you to say anything else? That's not law.
Right.
Let them run free.
Well, yeah, they don't give them any ideas. So what other aspects of this that we ought to be, the takeaways? I mean, my cause is your cause, which is to bring back our constitutional rights, due process, legal, an understandable legal framework that treats everybody the same, and we can get equal justice. Does this advance that? Is this a big step, a little step in that cause?
I think it's part of a big step. In some of the other cases that you noted, like Dobbs, Bruin, I think a large part of these rulings is just emphasizing how the Constitution works and how the Republic works, and just remembering why we have three branches of government that fulfill separate roles. You don't want one branch that can, on its own, do everything and take on whatever power it wants. And just, considering also we are in a federalist, republic, and there are states, the state involvement is a factor that I think a lot of people forget. And just this I think the agencies thing, they're just so pervasive now that people don't realize, how much power they are actually accumulating.
We don't want to talk about Dodd, it's too complicated, but just the idea that the Supreme Court didn't end abortion. It just said it's up to the states basically to decide.
Right.
And
that's going to be a very interesting discussion, one we should have had a long time ago.
It's not, we don't do that kind of law, but what I'm trying to get at, yes, the question if it's better, it is better. The real question is where are they going to go with this major questions doctrine, because Gorsuch doesn't agree. Gorsuch is very, very, first of all, he cites Phil Hamburger quite a bit, so we liked his opinion, right? We put in both Phil Hamburger and Mark Chernoff, and Rich Samp, they all put in an amicus brief for New Civil Liberties, and Gorsuch kind of took it about this. How much can you give to the agency? My do-good theory. But he has an interesting thing on the major questions, and the majority hasn't adopted it, but Kagan says, well, one of the it can't really be a major question if the agency is doing stuff Congress kind of knew it was going to do, because it's the EPA and it's dealing with the environment. It's not like that CDC case where they were dealing with evictions and they don't know anything about evictions, right? It's not like OSHA. She was basically saying if Congress makes administrative agency and says this is its area, if it does anything in that area, it's okay.
She also said the EPA experts know things that the Supreme Court doesn't know.
Yes.
So the Supreme Court ought to stay out of it.
There's no question, and she says.
I think she says that flat out.
Yeah.
Oh, she does. She says, and let's say the obvious: the stakes here are high. Yet the court today prevents congressionally authorized agency action to curb power plants' carbon dioxide emissions. The court appoints itself Instead of Congress or the expert agency, the decision maker on climate policy, I cannot think of many things more frightening. Respectfully, I dissent.
Respectfully.
Yeah, exactly.
You guys are all idiots.
Exactly. I hope. No offense.
I'm sure none was taken. How's the new justice influence all this? Is it a kind of a non because where Breyer was, is this just sort of more of the same, or is it going to be?
We'll see. I mean, she made a lot of remarks, before starting that were kind of originalist leaning, and we'll see if she's a textualist and adhering to those. That'd be interesting.
Well, I will say this. So I've been before her in the district court. I've never been before her in the appellate court, and I did a little thumbnail for New Civil Liberties on her rulings. She hasn't said anything about Chevron that she thinks it's bad. She applies it as a district court judge. What I think is interesting is that she has not always rubber stamped what the agency's done. And the other thing she's done that we like as litigators, but maybe as an originalist, is she keeps the agencies always want to say only their ALJs. They have unique jurisdiction for certain things that don't go in the district court. And when she's been reversed because she said, no, district courts have jurisdiction. You get Article 3 judges, not these ALJs. And she's been reversed. And, Alito was reversed years ago in Casey. He was reversed because one of the things was that a wife had to tell her husband before she got the abortion. He said that was not an undue burden, and he upheld that. And the Supreme Court reversed it. And he specifically wrote about it in Dobbs. I wonder if she's not going to do some jurisdictional stuff because she was a district court judge. She doesn't think they should be stripped of jurisdiction without really clear language from Congress. That might help. You never know how they're going to come out, I think.
Yeah.
I think Breyer was a little different than they thought. Certainly, Gorsuch on Indian rights is much different than some of his compatriots on the other side. Each of them has their own experience. I don't like. I'm happy to talk about it, but I don't like prejudging till I see, because when you're a district court, I too am a man under authority.
Also, you may have to argue in front of the Supreme Court.
That is true.
We're not going to pin you down on what you really think. Well, we need to wrap up here. It's great having you back on. These are issues that keep on giving. There's going to be a lot to talk about going forward. Casey Norman, welcome.
Thank you.
Glad you're here with New Civil Liberties Alliance. John Vecchione, you're senior litigator.
Yeah.
And it shows. I bet you're good at it. Anyway, this has been the Bill Walton Show, and we've been talking about EPA and other scope of government issues here. And I think I've learned a lot. I hope you have as well. As always, you can find the show on YouTube, Rumble. We're now publishing also on Substack and all the major podcast platforms, including Apple and Spotify. And hope you enjoyed it. And you can catch us with video or audio. And let us know what you think about the show. We like your ideas for shows going forward. So anyway, thanks for joining. Great. I hope you enjoyed the conversation. Want more? Click the subscribe button or head over to thebillwaltonshow.com to choose from over 100 episodes. You can also learn more about our guest on our Interesting People page. And send us your comments. We read every one, and your thoughts help us guide the show. If it's easier for you to listen, check out our podcast page and subscribe there. In return, we'll keep you informed about what's true, what's right, and what's next. Thanks for joining.